Hi, my name is Robert Chisholm, and I'm a founding partner of CCK. With me is Jenna Zellmer, and today we're talking about the Chisholm v. Collins case. That's right, it's about me. I was the client in this case for various reasons. And Jenna, you argued this case before the court. How would you summarize the court's findings?
Thanks, Robert. The court's ultimate finding is that while a supplemental claim needs to be filed on a form prescribed by the secretary, it doesn't need to be filed on VA's specific supplemental claim form. A different VA form, like the application for TDIU, can serve as a supplemental claim when it's filed after VA denies higher ratings for those disabilities.
So, what does that mean? What's at stake in this case? And how will this decision help other veterans?
Right, so it's important to know that a veteran can continuously pursue a claim by submitting a supplemental claim within 1 year of an unfavorable rating decision. This preserves the earliest effective date as the date of the initial claim. But when veterans submit something within a year, like a VA TDIU claim, an 8940, but not the specific supplemental claim form, VA has not been construing that as continuously pursued. And instead, VA cuts off the potential effective date, which in turn limits the amount of back pay a veteran can receive.
So that's kind of a mouthful. So let's break it down. Can you tell us about the facts of this specific case?
Yes. So here, within 1 year of VA denying higher ratings for our client's conditions, we filed an 8940, which is a request for TDIU. It's a specific VA claim form. VA took this as a new increased rating claim rather than associate it with the pending claim, the claim that had been prior denied within the year. So when VA awarded higher ratings, it only assigned an effective date back to the date of the latest submission, the 8940, rather than the earliest claim. And this also affected our ability to get paid for the work we did in obtaining those higher ratings because attorneys cannot be paid for filing new claims. We argued that the 8940 should count as a supplemental claim that continuously pursued the earlier rating decision. But VA argued that the supplemental claim could only be submitted on a VA Form 20-0995, which is VA's specific supplemental claim form. So in VA's eyes, the 8940 started a new claim stream.
So when they consider a new claim stream, it's not going all the way back, and potentially the veteran would lose lots of retroactive benefits.
Correct.
All right. So what happened?
So we appealed the VA decision on the fees to the CAVC, and we also separately appealed the effective date assigned for those higher ratings. And while our fee appeal was pending at the CAVC, we actually successfully obtained entitlement to TDIU effective from 2013. So essentially, VA recognized that the veteran's 8940 was associated with claims that began back in 2013, while at the same time arguing that the 8940 was a brand new claim that didn't entitle us to fees. So the CAVC found that the TDIU request was indeed a supplemental claim despite not being on VA's specific form, and therefore we could get paid for the work we performed in obtaining the higher rating for the veteran, and relatedly, the original effective date was preserved. So it's important to note that the CAVC did caveat its decision that it should not be read to require VA to accept all TDIU applications as supplemental claims for any denied rating decisions.
So this case really isn't about TDIU. Why is it such an important case?
So VA's forms requirement can't be used as a sword to impose substantive filing requirements that are not actually found in the regulation. In other words, this will make it a lot harder for VA to deny claims just because the wrong form was used. VA is supposed to be on the veteran's side, and this really reaffirms that.
Jenna, congratulations to you and our team, and thank you for winning this great case.
Thanks, Robert. It was fun.